ourselves to order. This is the ACUS Model Rules of Professional Conduct Enforcement and Discipline Subcommittee. We have an excellent draft by Lou Varelli and some wonderful comments and discussion with Professor Funk and Mr. Stock submitted as well. In terms of how we want to move forward, do we want to put up the most recent draft with Professor Funk's edits and look through that? And I'm open to suggestions if people prefer to move in any other way, please. Always feel free to jump in. Do we want to go through these section by section? Or do we want to have some larger general conversations, which I know we sort of started with before the meeting? Any preferences?
My preference, don't we have to tell who's here and say we're here, and is this not like a committee meeting?
We don't usually do a roll call.
Okay, great. Okay. I'm happy just to go through until we run into something hard, and then we can talk about bigger pictures.
I think that sounds fine. All right, let's just jump right in then. It would be nice if we could go through all these rules today. And as always, we'll do the best we can with this section and then always be able to come back to it if we need to. So 400, there were a number of changes suggested to break this up basically into 3 different sections. And I think more clearly delineate legal representatives versus non-legal representatives. That's a term we may be playing with, non-legal representatives. Any comments on the proposed changes? Or on this rule as it looks in this version?
I would just nitpicking, I think we've been calling them attorney representatives. So I think the first line would be an attorney representative, and the non-legal representative is a placeholder, but I think Bill understands that too. I think we're still working on that terminology. So for now, I would leave that there. Otherwise, I think this is a significant improvement on what I submitted. So I don't have any other comments.
Anyone else on the committee want to weigh in? All right, hearing none, let's move to 401. So this is initiating the enforcement proceedings, and I'll give everyone a chance to read it in case people didn't read the version that went out just before the meeting. Does anyone have any comments on this section?
There's a typo in the sub I.
Yeah.
Okay.
Do you want to scroll down a little bit perhaps so people can see? Yeah, it's probably good. And everyone should have a copy of this that was sent by email as well.
So Aaron, I don't want to just jump in. If I certainly want to turn
Nope.
anybody else jumping in.
Please do.
I like this approach very much. I think it reflects what the right way to think about it. I actually think we should probably account for a written complaint even in Part A, right? So we don't want to imply that there's waiver, right? If you don't raise it if you don't raise a complaint or an issue of conduct in a given proceeding, you can raise it later. You could submit a written complaint sort of, when you're not in session, or if you think of it later. or maybe I'm overdoing it, right?
No, I think that's correct. And I would think that within a proceeding would not just be the hearing, but where there's, pretrial, some sort of violation that occurs during the discovery or pretrial phase, a written complaint might be more appropriate at that part of the proceeding.
I just, instead of adding or submit, I just say that proceeding may make an oral or written complaint. Oral or written, it just makes it sort of shorter.
And we need a space between officer and which on the next line.
And I'm learning a comma before which, right? Isn't that, as my son studies for the ACT?
Sounds good.
All right. Any other? Go ahead.
I'm sorry, and I just have a question. Bill, I'm not sure I entirely get your meaning in small two. Shall provide the defendant with a description of the conduct or circumstances giving rise to the alleged violation. Is that assuming the adjudicator identified the conduct and is explaining what they think went wrong?
Yeah. And
okay, so this is just initiated. Okay, so we actually have a problem, just a complication in the language, because part A is assuming the adjudicator initiated it, and then part one, A1, is talking about a representative initiating it. Now I see that's what.
Correct.
Right. So we need to figure out how to accommodate both of those things.
If all of A applies to violations that occur within the conduct of a proceeding, then in one, would we need to say the specific proceeding? Or could we differentiate if the representative brings up the conduct, and then two would be if the presiding adjudicator brings up the conduct?
I think specific proceeding is correct. And I'm not sure why two is only appropriate if it's done by if it's initiated by the presiding adjudicator. Because if somebody makes a written complaint, well, then presumably the adjudicator should provide the defendant with the description of the circumstances giving rise to the alleged violation, in the complaint that somebody filed. Maybe just gives them a copy of the complaint, but the idea is it's notice, and that's all it's intended.
That's what I missed. So I didn't know if you meant notice or a description of the reasons for the decision.
No, not the decision.
Right. Okay, so that's just notice. I'm sorry,
Yeah.
there's a hand. I'll stop.
Go ahead, Bill.
Well, yeah, I mean, I think this is the then sort of overall question of, is this meant to replicate judicial authority over a hearing? In which case, if you have a hearing which is either ex parte or which involves a government representative of the agency before an ALJ of the agency, for example, you have an asymmetry, right? My understanding, and I defer to people who've worked for government more, is a presiding adjudicator who's an ALJ wouldn't have any disciplinary authority over the representative of the agency in the proceeding. And so, is it better to just divert any of these to a separate proceeding? Because only, so the presiding officer still has the authority to make a complaint, so to speak, but then that complaint has to get resolved within the context of the sort of an ancillary proceeding, which would have an independent adjudicator.
That's the ancillary proceedings. B is capital B, and what occurs there. A is what happens in the proceeding that the ALJ is presiding over, and whether or not it occurs actually physically in front of him, or whether, as Aaron mentioned, it might happen in pretrial type of motions or discovery or something or other. But the idea is that ALJ has authority over the non-government representative. I mean, none of this applies to government representatives.
Well, right, and That's why my point is that presents an asymmetry within the proceeding, which itself is a due process concern, and that therefore there shouldn't be an A, right? In other, there should just be one way that these things happen, which is that anybody before the agency or the agency itself, or whatever, can complain against a representative, which then doesn't happen in the hearing. It happens in a separate hearing in a disciplinary proceeding. I guess my perspective on this is colored by how this all got negotiated out with respect to the representatives in immigration proceedings, where there's actually a representative from a different government agency appearing before the Department of Justice. And so the way they kind of did it is they said, okay, there's this separate enforcement mechanism where you get a hearing before a separate Department of Justice administrative judge who's not part of the underlying proceeding, so that there's no question of unfairness to the respondent in the proceeding where the issue arose.
Well, I'm still trying to. Are you talking about having in the immigration situation, it was a government lawyer who was being potentially sanctioned?
No, this is the reason it came up in the immigration situation is that the AJ has no jurisdiction over the government lawyer, right? Like, they don't even work for the same department. And
Well,
so,
I
so they
understand.
said, look, like, you can't have a proceeding where one side gets to make complaints about conduct against the other representative, but the other representative doesn't get to make complaints against the government's representative, right? Like, that's, in a criminal trial, we'd say that was pretty terrible. If the prosecutor can make all the complaints they want against the judge can only hold the defense counsel in contempt, but not the prosecutor. Like, how is that going to work?
Well,
So I say, so
all I can say is that these model rules have always said, and in fact, the report, that's the underlying report, had always said, none of this applies to government lawyers. And so it was always the presumption that this would be a one-way street.
yeah, and I think you have, well, anyway, I'm advocating for the position that because of the due process concerns of that sort of one-way enforcement, that any allegation of a violation should go to an independent adjudicator and should be separate from the underlying proceeding. So that kind of goes back to that might need some, if everyone agrees, then we'd have to rewrite a couple of these, but that's the position I'm advocating for.
So I have a question about how that works, if I can jump in. What happens to the underlying proceeding? In other words, is that just stayed till the representative returns, or what happens to that proceeding? If you know.
Don't know. I think is the short answer, right? I don't know, but but I think that in addition, the rules similar to the model rules that we're proposing here, reach beyond sort of the immediate proceedings, right? So there's typically these allegations are brought because of a set of things that the government's become aware of, that it then realizes it's got to discipline a representative. If we're talking about, well, then how does the ALJ get to control the proceeding? Well, you have all those other tools. I mean, one is, and I'm going to refer this. Two is, but then the representatives can say, well, I think that's unfair, and so I'm going to make a motion for you to recuse yourself, right? So you can get to a little bit of a standoff there. And I think the adjudicator has other tools in terms of, the evidentiary rulings or whatever it may be, to sanction the misconduct or to take account of the misconduct.
In an ordinary civil trial in a court, the judge can impose civil contempt. It doesn't have to go to an independent adjudicator, a different judge.
Yes, but these are all executive branch officials, right? This is Lucia versus SEC. This is the whole question of these aren't judges, right? They are administrative officials. So, you know, that needs to be taken into account is my position.
Well,
I
I
think
don't know. It's you're going to what I'd say is a fundamental issue with these model rules, and it's not this section, it's the whole section, it's everything. This as to what the rules and the recommendation itself. I mean, the recommendation that ACUS adopted. All right, you know, I mean, these are the model rules under the recommendation, and the recommendation is allowing the adjudicator to make decisions.
Yeah, and look, I'm right. I'm trying to share a perspective to say you may have to have a. I mean, I'm leery of modeling the adjudicator's authority on what a judge could do, right? So it's similar to the question of an administrative subpoena. At the end of the day, if you ignore an administrative subpoena, the agency has no inherent authority to enforce that subpoena. They have to go to a judge to enforce the subpoena. Similarly, it strikes me that the more you assert a judge-like role, the more you open these things to challenge.
Go ahead, Jeremy.
Yeah, just to clarify, I think looking at the recommendation, at least since that came up, I think it just says agencies should address in their rules how complaints are adjudicated, who addresses them. I don't think it goes to this question of whether it has to be the adjudicator in the proceeding or not. So I think this debate can happen. Just Bill Funk, to your point here. So that might still be an open question. I will let others debate the merits of these different perspectives.
Well, I go back to the idea that, as Bill was talking, the other Bill was talking about, that in immigration, what they're really talking about is taking large-scale action outside of the particular proceeding against the person. And that's not what we're involved in here, at least with respect to lawyers. For lawyers, this is only about this particular proceeding. And I would say that an adjudicatory official, whether administrative or judicial, acting as a judge has the inherent authority to do an awful lot of things. And the model rules would make it clear that they have that authority. And I think they're exercising that authority now, even absent the rules. But the difference is it may be ad hoc and without direction from higher authority. But it's just whoever is running the hearing has to be able to run the hearing and not say, we're going to stop this hearing and go have another hearing about whether or not you're interfering with this hearing.
So can I ask a sort of empirical question? Because unfortunately, my experience is at an agency where there's no government representative, so I haven't dealt with this. But obviously, adversarial proceedings are pretty common across the executive branch. How do other non-immigration agencies, how does an ALJ at the NLRB, for example, handle a complaint against an NLRB employee? Is it the same process as for private sector attorneys? Is there an alternative disciplinary process with the general counsel's office? Do we have any information about that?
That's why we need George Cohen.
And my agency generally has private parties on both sides. So no experience with this either. Does anyone else have any other experiences from other agencies they could share?
No experience, but I'm pretty darn sure that if there's a problem with the government attorney, that the issue would be to go to the government attorney's supervisor or director, whether a general counsel or whatever form of the structure is. That would be the way to do it, and they would do it as a personnel matter, right, rather than something else. But okay, that's a big picture question, right? Which I think maybe if we could sort of get beyond that and say, well, all right, if we were going to say, yeah, there is a two-track system that can either be done before the presiding adjudicator, or there's an alternative way if it doesn't occur in the proceeding, there's some underlying problem. The guy was convicted of fraud, and therefore we don't want him to be, you know, in this thing. But so we're going to have a hearing outside of our hearing. Is this language okay if we accept that as a premise? If that premise isn't, if we throw the premise out, then everything goes back to square one, so to speak. But if we don't go back to square one, is this okay?
Is there maybe room for sort of language in a comment highlighting Bill Stock's concern in an adjudication where only one of the representatives is subject to the rules? Presiding adjudicators should take into account concerns about fairness, something like that. And I wouldn't say due process, not because I think it's irrelevant, because I think, you know, that's a
Yeah, fair enough.
yeah, correct. Everybody understands me.
I'd say in an adjudication where one of the parties is the government, or an agency, or the agency. Any complaint with respect to the agency's representative should be made to that attorney's office. I mean, that's the idea.
I've found the phrase designated agency official in brackets to be liberating, Bill. I use it everywhere when I don't know the answer.
Is it?
I mean, I also would say, Louis, if we're putting this in the comments, right? I mean, I think a better way to capture my concern would be to say something along the lines of that in using these model rules, agencies, you know, applying them, this is going to be a mess, but basically the idea that agencies who are applying them to adversarial proceedings where the agency is represented may wish to divert disciplinary matters to an independent adjudicator rather than you know, to the same official who's holding the hearing. Significant wordsmithing may be necessary on that.
We could say independent may divert matters to independent adjudicator. We sort of reference the part of the rule that talks about the subsection of the rule that talks about an independent hearing or a separate hearing.
Right. I mean, I guess the
divert the disciplinary matters to a hearing as described in, or a hearing under subsection whatever.
Right. And I think, I guess what I'm trying to say is, you know, if you're setting out these rules for that situation, you might only want to have B, not A.
Right. And I think both those comments, both Bill's comments in number 6 here are worth keeping. Mm-hmm. And I agree they're not the same, but I think they both reflect an important idea. I have to just scroll up to see which subsection they apply to, but I think it's A. I think it's A, right?
Well, the number 6. Well, it's sort of choice of A versus B, right? Are you going to keep it within the proceeding or send it to its own proceeding?
I guess actually Bill Funk's comment in number 6 could be in general. Mm-hmm. It could be a comment to the entire Rule 401. So, and it would be first on the list. And then the number 7 would be to subsection. I've lost track now. I apologize, Matt.
Specifically to subsection A.
A, yeah.
Well, I mean, I'm just, to say that they may, if they wish, do that. I suppose I don't have a lot of problems with it. I think the question becomes, well, why would they? All right. And that becomes, or what, in other words, again, if something happens in the proceeding before the adjudicator, the idea that you're going to stop the adjudication and say, oops, everybody go home, because we're going to take a couple of months to have a separate proceeding to decide whether or not this person should be sanctioned by giving him a reprimand. Right? It just doesn't make any sense to me. And I certainly don't see it as a due process issue. All right. As I say, because I'm sure it's happening already. And
well, I would say empirically, I mean, at least in the immigration space with which I'm most familiar, judges manage to hold tens of thousands of hearings a month, without contempt power. So clearly there are constraints on a representative of a party, that are, they want their client to win, so they're not likely to tick off the judge too much.
Well, they might engage in ex parte communications. They might do all sorts of things. The question is, the issue you were raising is if you were going to take action against the attorney to essentially say you can't appear in immigration proceedings anymore, right? Right. And these model rules don't apply to them. Never. They can't do that.
For attorneys, correct?
Well, actually, so yeah, I think it is interesting that we've chosen to carve attorneys out. That essentially the remedy for an agency is to sort of say, okay, now I've got to file a complaint with the disciplinary board, and if the disciplinary board debars them, that's fine. That's actually not the model that's used in immigration. So the EOIR can independently say, you're not disbarred, but you are disbarred from appearing before EOIR.
I understand that, and that's not the only agency that does that, right? But these rules don't address that situation. These rules only address actions against an attorney in the particular proceeding that's going forward.
But they could be removed from that proceeding.
But they could be removed from that proceeding, all right?
And that's something that's problematic maybe to a lesser degree, but that's problematic in the context of the proceeding for sure. We want to make sure that we're accommodating at least the appearance of an imbalance.
Well, as I said, it's fine to say, you can complain about the government representative, but we don't do it under these rules, right? And the recommendation expressly says the recommendation doesn't apply to government attorneys, right, Jeremy? I'm pretty sure about that. So we can carve out and say that's a separate issue. You go complain to the government attorney's office, just like we don't say these rules don't apply to taking action against attorneys in a broader sense. That's in fact the comment to section 400. All right, the comment that I added to section 400. The limitation of disciplinary authority in these rules to the particular proceeding does not limit whatever authority the agency may have to impose discipline on lawyers beyond the scope of these rules. And that's the stuff that the other bill is talking about, really. That's that the immigration is involved with, something outside these rules. But I think we should move on, because again, I think I'd just like to sort of say, what can we agree on? And if I can certainly agree for the first change that we made. And I guess I don't have any problem with saying that the agency may, if it wishes, all right, subject it to something else. I just think that's addressing problems that I don't think exist here, because it's dealing with the problem of when you're going to get rid of the lawyer for lots of proceedings, not just the particular one. But maybe we should just go on to the next section.
Are people comfortable with the comments that we have? Is there anything we should adjust in those first two comments? Or should we move on to the next section? Knowing that this is not our last opportunity to review this or talk through it, and maybe we'll come up with some better ideas as we continue moving.
Yeah, I'm definitely fine with that.
Okay, great. Let's go to 402. So this is describing the enforcement hearings. Does anybody want to weigh in on this section?
Well, the only changes I made here was to take C, what used to be C, and put it in 401, and also the second sentence in what used to be E. So that's not substantive changes. I didn't understand what's now the new C or old D. I just didn't understand what it was referring to. If an alleged violation is not limited to a specific proceeding, then the alleged violation may be resolved by the designated agency official. I didn't know what that meant. I mean,
dare I say that sounds like a question for me. I'm imagining sort of misconduct in the more general sense, right? Failure to disclose a criminal violation, right? Sort of things that are not specific to the proceeding, but that may be discovered while somebody's acting as a representative and may need to be brought up. I thought of that as separate from conduct within the specific proceeding. But I agree, in most of these cases, if you're not currently acting as a representative, none of this would be relevant. So there's a bit of a timing thing going on.
I mean, I just wondered, I was wondering if you took it out, if you just dropped it, what you'd lose. In other words, could the alleged violation always be resolved by the designated agency official, whether or not it's limited to a specific proceeding? I mean, maybe it would be a comment as to, something, but I just didn't. Do you understand my problem, Lou?
Yeah, I was in light of the old C, I was contrasting the two, right? So if it happens in real time, I wanted to accommodate what you were thinking about, Bill, which is if something happens in real time, I want the presiding adjudicator to be able to do something about it the way I think we would all assume they would. Bill Stock's comments, notwithstanding and understood. And D was the alternative to that, right? If it happens somewhere else, then you can bring it somewhere else. But since you've broken them out, I think it may, I haven't thought about 401 and 402 holistically for very long since I just saw them, but I think you're right. I think the new C could probably go in light of what we've done in 401.
Yeah, I agree. So we can just drop it because it's okay. Now I did make a substantive change in the new D, old F. You had clear and convincing evidence. I put in preponderance of the evidence. I didn't know why clear and convincing which should be the standard.
I think I put a comment saying, help me with this, committee. I just threw something in. I wanted to make sure that we were thinking about the burden of proof. One agency uses clear and convincing, and I forgot who I cited for it. The VA. Is it the VA? Yeah, I borrowed it from the VA, but I wanted to raise it, most importantly.
Okay, I suppose what we could do would be put in there in brackets,
Well, I'm not advocating for clear and convincing. I mostly wanted to get consideration of it. That's all.
Is there anybody who is not comfortable with preponderance of the evidence?
Well, apparently the VA. I mean, this is this is where George Cohen would really be helpful. So why don't we put brackets around clear and convincing and preponderance of the evidence, and the idea that these are model rules, but an agency might want to use one standard versus the other. I think, generally speaking, preponderance of the evidence is the appropriate standard, but I'd certainly like to George about it. So I think just putting brackets around it, flagging it.
Agreed. And the two examples cited in the comments sort of give examples of both. That DOL language could be read either way.
Yep.
Do we want to look at the comments and see if anybody has any additional comments for the comments?
There's a says the subsection. There's a comment number 4 and 5 and 6 refer to particular subsections, which we've changed the letters of. So that may have those should be changed.
That's something we can do when we're cleaning up as well.
Yep.
All right, anything else on 402? Let's move forward to 403 then. And this has to do with the orders. Any comments for 403?
Just one question. So since we took out 402, Lou, as you originally drafted it, actually specified who the adjudicator was in different proceedings. Now we just say the adjudicator presiding over an enforcement hearing. I presume the adjudicator could vary depending on the circumstances, right? If someone is just disbarred, they're not currently representing anyone before a proceeding, before the agency, there might be a process to de-accredit a non-lawyer representative, and there might be a hearing that results from that, and that might be different from something that happens in a particular proceeding. Do we need to specify who the adjudicator is in different circumstances?
Not, if I understand, I think not, or at least maybe not, because this just says the adjudicator presiding over an enforcement hearing under 402. So as long as we are enforcing, that
Right.
could be the designated agency official or the adjudicator that presided over the original proceeding that gave rise to the enforcement, to an enforcement action or an enforcement.
I guess I'm going back to 402. Apologies, Aaron. Do we specify who the adjudicator is at this point?
Only between the official presiding over the original proceeding. So, although this might have all moved to 401 now, so that's
okay. Maybe that's my confusion.
So
Mhm.
yeah.
Yeah, I think it's in 401 now.
And I'm getting ready to run to my printer to get Bill's comments in hard copy because I am still a creature of hard copies. But before I do that,
yes.
Presiding adjudicator in this case means the adjudicator presiding over the specific proceeding within which, at least that's what it's meant to mean, right? If it's not clear enough, that's something that's important to discuss.
In 401B, it says submission of a complaint in writing to an agency official designated to submit such complaints.
Great. So as long as adjudicator encompasses designated official who might not have the title of judge, I guess we're okay.
Yeah, and I think it's then we need to clarify, which we do in the current rule we're looking at, that it's the adjudicator of the enforcement proceeding, which may or may not be the same adjudicator in the merits of the proceeding.
Right. It might be a debarment officer or something like that we don't typically think as an adjudicator.
Right. So should we say the agency official presiding over the enforcement proceeding? Or then now we're introducing more definitions, that's all. We could put in a comment that this person could be, but I don't know, I mean,
I think they're right.
I've used adjudicator, I think, very generically to be anyone issuing an order so far.
I think that's fine. As long as I think it's clear and consistent, I think I have no concerns about that.
Well, and that's going to be the rub, right? But that's a problem for another day. Yeah.
Yeah, I do like agency official because it helps distinguish from the adjudicator of the merits. Anything else on 403?
I'm just running to my printer. I'm not disappearing.
Yeah, that's fine. So to 404 is sanctions. Any comments on the sanctions provisions? And I think there were earlier comments about civil penalties, payment of fees, that sort of thing. It looks like those have been taken out.
I recommend take them out as well as somebody else.
Yeah.
Also recommended that. And in the third bullet, I added of a non-attorney representative because you can't do that to the attorney representative. And then I also had under the at the end of the second bullet, I said and question mark, and then the question mark was that, you know, I thought there were all these other things that might also be possible sanctions, such as, you know, indeed even giving making the person lose the proceeding, the party lose the proceeding on the basis. I mean, in the APA allows for when there's a willful ex parte violation to give judgment for the non-violating party. That might be something here as well. But there was other things as well as that I thought might be involved in, such as, you know, changing the timing for proceedings, moving if somebody's trying to delay and the judge thinks that the representative is trying to delay things, that they could move schedules up, and that would be something in that order. So I didn't know whether we should try to make a list or say could include the following sanctions and leave it sort of open, or whether we wanted to actually make a defined exclusive list. And so that was sort of my big picture question.
So, Aaron, if I may, I think one way I was thinking about this bill is that the other things you mentioned largely aren't sanctions on the representative, right? They are consequences of misconduct, but they're generally to the represented entity, to the participant, right? Losing doesn't harm the representative directly, at least. There isn't a sanction on the representative, timing changes. So that was my dilemma, right? If we want to make it about, because we've talked several times throughout the model rule process about focusing on the representative and not telling judges what to do, not right. Sort of, it doesn't mean. I think your point is exactly right, that those things should be available, and to the extent that we want to make that clear, I support that. But in terms of a sanction, I don't know if that qualifies as a sanction on the representative, and that was the line I was worried about. I was trying to navigate.
Okay, I can see that.
Because I was thinking of monetary penalties being levied on the representative.
Yeah, I understand.
And I don't object to them going away, right? I mean, the Supreme Court may tell us that we're not allowed to have them any minute, at least without a jury trial. But we could certainly, I think, in a comment suggest that this doesn't preclude, or right in the rule, this doesn't preclude the presiding official or from making other decisions. I don't know, based on misconduct, you know, making, I don't know how to.
Louis, I think I would agree with where you're going and say that it really goes in a comment to say that, yeah, maybe the first comment to say these rules apply to sanctions and not to, and shouldn't, like a sort of a savings clause, shouldn't be construed to limit the adjudicating official's ability to
Manage the
whatever,
proceeding.
like make evidentiary rulings, blah, 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 based on the conduct of a representative.
I wonder, does manage the proceeding adequately do it, Bill? Or do you want to be more specific?
I think just manage the proceeding is probably good. And I'd leave off the evidentiary ruling because that's really got nothing to do with it. I like, yeah.
Well, I guess, Bill, wouldn't you want some sort of some sort of examples of what you mean by manage the proceeding, right? In other words, like rule against the party, right? I mean, I get it. I'm not sure I know enough to say what those specific things should be, but I think what we're trying to say here is like all we're defining here is the sanctions. We're not defining other things that a adjudicating official can do when managing a proceeding.
Yeah.
Excluding evidence might go in here.
No, take out the last one. Take out the or issuing judgment.
Bill, do you basically want that list in 556C? Like, I mean, not the whole list, but that's like rule on offers of proof, receive relevant evidence, regulate the course of the hearing, pose a procedural requests, like some of those sorts of things.
We could just cite 556C.
No, it's some of it's sort of like punishment in the sense of you said you want more time, but you've been delaying so much. I'm not going to give you more time. I'm going to give you less time. Just been trying to delay this thing too long. Now, that you could say that's just managing the proceeding, or you could call it a sanction. I'm not sure, but that was my, as I said, I was thinking about what the judge has been doing for Trump and his lawyers, and it hasn't sanctioned them in the sense of censured them or reprimanded. Maybe actually he did reprimand them. I think he did. I just like limiting motions, changing dates and time to proceeding, or excluding evidence. That's fine. I think that's good. I don't think you need, it's examples. We don't need a whole list.
Should that maybe go as a second sentence to what was originally comment 1? So I think that to the extent that we think that the first original comment, the representative participant shall not be sanctioned, is true, then I think maybe we follow that up. We lead with that and follow up with these do not apply to management of the proceeding. Or am I conflating things?
I think you're conflating. I think
it wouldn't be the first time.
I mean, they're separate ideas.
I just make one weak plea to have the original leading comment stay the leading one.
Fine
The representative participant shall not be sanctioned. Just because I think that tells a story as to what we're doing in the rule that's really important. Right? We're focused on the representative. That I think if that's true, that should color how the second comment is employed.
Do we want to say something about whether this is an all-inclusive list in A, or if these are a non-exclusive list of potential sanctions? Which I assume would go in a comment.
Well, it would depend on the language introducing it. Does it say these are the sanctions, or sanctions may include? May be subject to the following sanctions. That's pretty, I'd call exclusive. So if you want, this is the exclusive list as it's written now. And the alternative would be to say sanctions could include.
Do we want this to be do we want a broader? Well, what do people think about that?
I mean, it seems to me that the agency in its rules should provide an exclusive list. That said, we may not be able to provide the exclusive list. So saying in a comment something like, of course, agencies should provide an exclusive list in their rules, but of course, agencies may go beyond this list in developing that rule. I mean, there might be some case in which fee shifting or monetary penalties are permitted by statute that we don't know about. Is that sort of what you're getting at, Aaron?
Yeah. What do people think?
I'm not sure it should go in a comment because it seems to me, I mean, if these are sort of like the ABA model rules, the ABA model rules have comments, and the comments explain what's in the actual rule, rather than sort of here advising people what they might consider changing the rule to be. So I think if you wanted to do that, then I'd put down here under a fourth bullet, in brackets, such other sanctions as the agency may desire. And I think that's good.
Yeah, I think that's great.
Do we maybe deem appropriate in lieu of desire?
Sure.
And it may depend on what authorities different agencies have in terms of what they can impose.
And then we can take out the comment.
Mhm.
And then my suggestion was to take out the last comment because that referred to the monetary penalties. So.
All right, so if we're comfortable with A, are there any other factors that should be considered in B?
We're calling that's the presiding agency official now, right? In the enforcement proceeding. We made that change in the last rule, I think. I know it's my fault it says in, but maybe it should be over the presiding. Can you preside? You preside in something you do, right? I defer. I don't know.
It's over in the previous one appearance, so whatever we choose, we should
Right.
make it consistent.
All right, any other comments on the factors or on the sanction section?
So is this meant to be an exclusive list or no? I only ask because A and B have a very similar subject construction, may be subject to, may consider, and we've said in the first one it should be exclusive. Is B meant to be exclusive?
I don't think it should be exclusive. For example, I can think of a fifth bullet, which would be
Right.
the impact on the party of removing the person from the case. So that's, I mean, it's something that should be taken into consideration.
Right. Yeah, I mean, I don't think it should be exclusive, but we may just want to clarify, even if it's a fifth bullet that says something like any other reasonable factor, something like that.
And you can take out the no, that's good. That's good. Yeah, that's good.
Although I actually might not put it in brackets. I might actually have it as any other factors the presiding official deems appropriate. I mean, this is, I think, meant to be, even in the agency's own rules, a non-exclusive list.
Correct. Right. capital S at the beginning of the bullet, but. Okay.
Excellent. We're more than halfway done. Move on to 405 petitions for review. I think this is one of the issues we were discussing before we sort of officially started.
Yeah, there's a comment that I had under this thing, which was, do we want to have petitions for review at all? And the idea is, to the extent that we're talking about a particular proceeding, that to provide for a petition for review may mean that that proceeding gets delayed very long time. And I don't know if that's worth it. Somebody's going to reprimand somebody for something, and if the person who's being reprimanded for delaying the proceeding, and now he says, I want to appeal this reprimand, right? Now we have to stop the proceeding, or not. That's sort of the question. And I just wonder whether or not this is worth it. And then, as I said, that if we want to have a petition for review, then we want to make it a required exhaustion requirement, because if we do, we have to get the right language, but also it would mean that the order would not be effective pending the review. And that's another downside to having the review at all. And I said, well, why not just have them be able to go right to court after either the separate proceeding to impose the sanction, or go right to court for whatever the presiding adjudicator does. And I didn't see a real bad sign to that.
Jeremy?
Should get better at raising my hand. Again, this might be a case where this sort of split thing, there's a difference between sanctions in the context of an individual proceeding and more generalized sanctions like suspension or disbarment, I think.
We can't do that. We can't do that.
For attorneys, but for non-attorneys, again, that might be, in that case, you may want a petition for review process where a non-attorney qualified representative is suspended from practicing before the agency. You may want a separate petition for review process. So this might be a case where you want to have separate tracks and maybe carve off attorneys and non-attorneys.
And carve it out as being, if the sanction is something beyond the particular proceeding.
Right.
So no quick, why don't we just, again, if we're agreed with that, and I think that's a good solution, then why don't we just not try to draft it here? All right.
Agreed.
Give it back to Lou or staff or something, whether to have the petitions for review limited to non-lawyers for circumstances or sanctions that go beyond the particular proceeding.
Good, and I would just ask Matt to include that last part there. I'm listening, but I want to make sure I don't forget that. Sanctions, right? And that makes sense to me.
So moving on from petitions for review, the next section is disciplinary referrals. And this applies, I would assume, to both attorney and non-attorneys in the event that the non-attorney is like a CPA or something where there is some sort of professional body to which someone could be referred. Any comments on the referral process? I think in all of these, we would change the adjudicator to agency official.
the typo in the last fourth line from the bottom.
All right, anything else on referral? Oh, Jeremy, sorry.
Yeah, do you want any intra-agency referrals here? I mean, there might be cases in which an individual adjudicators reach a decision that might be referred, for example, to a disbarment officer or a suspension officer. That's obviously agency dependent, but I know that exists at some agencies.
All right, good. Anything else on disciplinary referrals? We can move down to 407, reciprocal discipline. Any comments on this section? All right, and then the last rule is 408, improper complaints. Any comments or concerns about this one?
We should check the reference, given what we did to 401.
Yeah.
I'd just say under 401, I wouldn't even specify because it would either be A or B, because somebody could file a complaint under either A or B. So
Yeah, rule 401.
The reason, the only, and I don't have a problem with that. The only reason I was that specific is that I really only wanted it to apply to other participants' complaints. I didn't want to imply that a presiding official could have a frivolous complaint. I'm not suggesting it's impossible, but I didn't want to be in that position. So I thought what we're dealing with here is sort of the one party, for lack of a better word, attacking another frivolously.
well, we do limit it to a complaint from representative.
Right, good. Oh no, right, good.
If you hear the background noise, it's because they're tearing down my house around.
So thank you all very much for the comments and for working through all of these sections. Do we think we will need another subcommittee section to review these? Are we comfortable sort of with where they are and moving on? Or do we want to take some time to consider? I think the next section up is the last section, transparency and reporting.
I would really like to go over these again with George Cohen here, and Wendy Muchman too. Isn't she on this committee?
Wendy Muchman is on this committee. George Cohen is not. We had two of the
Well,
four members of this subcommittee at this meeting today.
And the ABA, the other ABA representative, that's not Wendy Muchman? Do we know who the other ABA representative is to the model rules group offhand, besides me?
Let me see if I can bring that up quickly.
Do we think a meeting would be helpful as opposed to circulating the draft? And then seeing if people have additional comments or want to discuss further. I mean, some of the issues I'm not sure we'll get complete consensus on, but hopefully can move towards that.
I would really feel more comfortable if George Cohen could at least review these, and if he has problems, then I think it's worth having another meeting. Might be a short meeting, but George knows some of this stuff better than any of us, so I just think it'd be really worthwhile. I mean, I made these various recommendations, but I'd really like him to take a look at it, and get his feedback on it.
Well, we will work on that, and we'll coordinate with ACUS as well, and ensure that the committee and George has full opportunity to provide input. Thank you all very much. Is there anything, especially Lou or anyone would like to add before we conclude for today?
Just my gratitude for everybody's work. I'm grateful for all of Bill's thoughtful comments. I think many of them, the overwhelming majority, if not all of them, will stick. So it's much better for the work today.
Thank you.
Thank you all very much. We very much appreciate your time and your comments, and we will be in touch when we're ready to schedule the next meeting.
And thank you, Matt, for putting up with my very late comments.
That's the highlight of my week. Thank you all on behalf of ACUS. We really appreciate you volunteering your time on this effort, and we'll see you soon. Lou, I will send this to you immediately, and then we'll circle back to everyone on the committee when we have some edits from you.
Sounds good. Thanks
very much, everybody. A lot of good work today. Thank you, Madam Chair and Lou. See you next time.
Thank you all very much.
Thanks, everyone.